In the next hour, Simon will discuss the recent English Court of Appeal decision in the Sea Challenger. This was a case which raised important issues, such as what information can constitute a representation, and when is a reservation of rights ineffective to preserve a party's rights. He will also offer practical advice to owners and charterers from lessons learned in this case. We will have a Q&A session at the end of Simon's presentation, so please feel free to drop your questions in the Q&A box in the course of the webinar, and I will present your questions to him during the Q&A session. Without further ado, I would now like to invite Simon to deliver his presentation. Over to you, Simon.
Thank you very much indeed, Trishli. And may I say what a great honour and a privilege it is to be asked by the Society to give this lecture. The International Malaysian Society of Maritime Law is well known to me, and its work in developing maritime thinking is highly important. And so it is a great honour to be asked to give this presentation. As Trishli said, I'm going to be talking about the Sea Challenger. And as Trishli also said, the Sea Challenger threw up a large number of points. There were 6 issues in the Court of Appeal, and I'm only going to be dealing with one in detail, which is the misrepresentation issue, but also the reservation of rights issue, which I think is a sting in the tail for maritime lawyers if they're not careful. So without any further ado, I will ask Sean to put up the first slide. And you will see from the first slide that I've titled this Speed and Consumption Warranties after Sea Challenger with a question, anything goes. Because as Trishli said, what this case raises is an important issue about whether you ever can have a claim for misrepresentation in relation to information given by an owner to a charterer about what his vessel does in terms of speed and consumption. Next slide, please. Here is the Sea Challenger, and as I've said there, the principal issue is whether any information given by an owner to a charterer about speed and consumption can amount to a representation at all, or even a misrepresentation. Next slide, please. Why does this matter? Well, at the very heart of the time charter party bargain between owners and charterers it is the trade-off between the owner providing the services of the vessel and the charterer having to pay for the running costs of the vessel in terms of bunkers and of course hire. And the impact of speed and consumption figures upon the economic bargain for the charterer can be pretty important. We've seen in the recent past with COVID-19 and now with problems, tragic problems in the Ukraine, that world events can have a very, very big and very sudden effect on fuel and energy prices. And no one is more affected than a charterer in terms of massive increases in bunker costs. So speed and consumption information, when it's given by an owner as part of the negotiations or just in marketing his vessels out on the market, is going to be very important to a charterer. And charterers will carry out, as they did in this case, extensive calculations to work out how the deal works and whether the return on hire and bunkers and what the sub-charter position is going to be and what the costs of that are going to be, whether it all makes economic sense and is a suitably profitable or a feasible economic deal. And so when information is given by an owner to a charterer, and I want you just to have this in mind as we consider the facts of this case, why is it being given? As we'll see, Lord Justice Mayles in the Court of Appeal emphasised that the reason this information is given is to say, look, my vessels are good. You charter mine, not his or his. And so these figures really lie at the heart of the interchange in negotiations and at the heart of the economic bargain that owners and charters will eventually end up making. Next slide, please. Next slide, please, he said. Thank you very much indeed. So let's turn to the facts. And the facts are important Well, the facts are important in any case, of course, but the facts are particularly important here because they are very different from a leading English case, which I want to consider with you in a little bit of detail a little later on in this presentation. The background to the whole problem that happened in this case was that SK Shipping were and are experienced tanker owners, but they were previously very big in chartering their vessels on the voyage charter market. But in October 2016, they decided to come out of the spot market, in which they'd been carrying out of their business through consecutive voyage charter parties, and taking a view of the freight rates, which they thought were going to be available for VLCCs long term, they decided to remodel their business to charter the vessels out on long-term time charter parties. And that made it necessary, because you don't get speed and consumption warranties in voyage charter parties, but you always do in time charter parties, or you invariably do. And so that meant that they had to come up with speed and consumption figures for the first time. And as Lord Justice Males said in the Court of Appeal, speed and consumption warranties, which specify the amount of fuel consumed at specified speeds and in specified weather and sea conditions, are a standard feature of time charter parties. The task of determining how you put together the speed and consumption warranties was given to Mr. Kim of SK Shipping's tanker operation team. And the problem started immediately because everything started to unravel straight away. As Lord Justice Males put it, as Mr. Justice Foxton put it at first instance, unfortunately, Mr. Kim did not have the expertise required for this task. He failed to understand properly the noon reports provided to him and did not consider the vessel engine RPMs, not a very good start, you may think, ladies and gentlemen, which were critical to an assessment of their fuel consumption. In addition, he worked on the basis of out-of-date consumption figures from the vessel's sea trials, and these vessels were not new, which did not accurately reflect their most recent performance. So you could see problems were instantly going to come about. Next slide, please. And what, after Mr. Kim had put his mind to speed and consumption figures, what was then sent out, and this is important for the facts, what was then sent out to brokers on the market was what came to be called in the case a market circular. It was slightly different from this when it actually got to my clients, but this was the market circular which was sent out. I don't ask you, ladies and gentlemen, to strain your eyes to try to read it, but I thought I'd show you an original document from the case. This is where it all started. This is where all the problems started. And it was sent out to all brokers announcing, as Mr. Kim put it, please be advised the speed and bunker consumption of our candidate vessels for time charter party out. Those words weren't then included in what was passed to us, but you can see that what was being put forward were speed and consumption figures effectively actual and current. Can I ask you to turn to the next slide, please? So let me now analyze with you a little bit what that document, which I showed you illegibly, actually said. Mr. Kim put out a market circular. And again, I ask you to bear in mind the essential facts, because they're different from those considered in a previous case, which the Court of Appeal and Mr. Justice Foxton thought important. Mr. Kim sent out a market circular to various brokers describing the vessels that they had in the fleet, all four of them. As the Court of Appeal stated, I said I'd come back to this, this is Lord Justice Males, it is in the ship owner's interest to present its vessel to the market in the most favourable light in order to secure employment against competition from her owners. And I'll come back to that because that's important. Why is this information being given? What is it being sought to do in the minds of brokers and charterers? And here is the text which you couldn't read on the slide before, that I've typed out for you. Fuel oil, excuse me, fuel oil bunker consumption. Now this figure is the sum of main engine, etc., daily consumption, and in three essential parts, which I've highlighted in red for you to have a look at. One, above data is based on the average of the last 3 voyages. And I've underlined that, and we'll come back to what that means. and might be different depending on seasonal ocean currents and weather conditions. 2, speed and consumption basis normal weather and wind force up to and including Beaufort scale 4. So that's telling you the range in which those figures can be relied. And then this, 0.5 knot margin required on the charter party. So a margin on those figures was being asked, but one question I want you to have in mind when we're looking at the facts is, what did that statement, 0.5 knot margin required on the charter party, tell you about the figures which were set out in the great big box above? Unfortunately, the November circular was provided to the market without being checked by SK Shipping's ship management team, because had they checked it, it would have been obvious that the figures in the circular did not reflect the vessel's most recent performance. So it was, if you like, it was a chapter of calamities. Next slide, please. So the market circular went out, brokers distributed it to their clients, and a fish bit my clients in the Court of Appeal, Capital Maritime, on the basis of the market circular, entered into negotiations with SK Shipping. And importantly, the information and that little bit of text effectively remained the same throughout the negotiations. You know, your counter, last counter, accept, and all the rest of it, the usual counters that went backwards and forwards. That text sort of tracked all the way through to the end. But in the end, a charter party was concluded on the Shell Time 4 form. And you'll know that the Shell Time 4 form in clause 24 has got various speed and consumption provisions. The speed and consumption figures set out in the circular, together with most of the accompanying text, but omitting the explanation that the above data is based on the average of the last 3 voyages, was then set out in the charter party. And the Court of Appeal thought that was significant, as Lord Justice Mail said, thus the terms put forward in the negotiation had not included the statement as to the vessel's last 3 voyages. The owner had simply indicated the warranties which it was prepared to give without explanation. And one thing you will have to consider when you're thinking of the facts as we track these through is, does that make a difference? If you have the same representation, or what we said was a representation, being made at the beginning, and then being repeated over and over again in the extensive negotiations, and then in a very slightly different form, making it into the charter party with the figures, does that and should that make a difference? Next slide, please. Well, this is a chart I found online, speed and consumption claims, all the factors that come into account, which I thought you'd be interested to see. As you can see from the facts, that I've already set out, a disaster was coming, and it came very quick. The figures were way out for consumption, and almost straight away in the beginning of the charter party, which were 2-year time charters, the vessels significantly overconsumed, and the owners, the charters started to suffer losses and started to complain about what had happened. There was then a big debate between the parties, and this will be important for the reservation of rights issue, because the owners kept saying, oh, there's no problem, it must be hull fouling, or give us 6 months because we can work something out, and we're investigating it. And the charterers reserving their rights said, oh, okay, we'll give you that time, but you know, we're reserving our rights. And I'll come on to that at the end. So next slide, please. Eight months in, Capital had had enough, as it were, and they terminated the charter parties on various bases, but for today's purposes, the only basis which we're concerned with is rescission under the Misrepresentation Act of 1967 on the basis of fraudulent, alternatively negligent misrepresentation. SK Shipping accepted that as a repudiatory breach by Capital because they said that the termination was wrongful, Capital having no right to terminate. Next slide, please. So there are the four matters which anybody in a misrepresentation case will have to show, and which Capital had the burden of showing in this case. Capital had to show a representation. Capital had to show that it was false. Capital had to show it was made fraudulently or negligently. In the end, the fraud claim failed, but as we'll see, the negligent claim succeeded, and on which it relied. Now, you can see that the easy bits arising out of the facts, which I've just been describing to you, were 2 and 3, because they were obviously false, because they didn't bear any correspondence to any real figures, really. And they were either made fraudulently, but the judge held that they weren't, and there was no appeal from that, or they were made negligently. Plainly, they were made negligently because Mr. Kim didn't know what he was doing, and no one bothered to check what he'd done. So that brings us on to the issues in the case. Capital, with those four things to show, had a problem. And the problem is the existing state of English case law on misrepresentations and representations, which subsequently become terms of the contract. Next slide, please. And there is, as many of you will know, and there's a similar body of authority in Singapore law, there is a body of case law that deals with what happens when representations are made to induce a contract before a contract is concluded, which then end up as terms of the contract, and which also deal with whether a statement made in negotiations as to a term which a party is willing to enter into if the contract is concluded can ever itself amount to a representation, or whether it is simply a present offer of a future intention to contract on the basis of that term. And there are two strands to that case law, which is very important to have in mind as the background to both what happened in the first instance court, in the commercial court, and in the Court of Appeal. Next slide, please. The first strand is a strand of cases which I think culminated in the decision of Andrew Baker QC, sitting as a deputy judge of the commercial court, in a case called Idemitsu and Sumitomo, a case which I won in 2016, and where Andrew Baker considered all of the cases in a magisterial analysis, I think, very typical of that judge, and summarized the law. And I want to just take you to two passages, one in a case which he cited, and one in the case itself. Idemitsu and Sumitomo was about a share sale and purchase. And what the share sale and purchase contained were, in the negotiations, there was a slab of warranties. And the question was whether the warranties about the company, share capital, etc., were actually representations, or whether they were simply warranties when they got into the contract. And what this first strand of authority shows is that the mere offer of contract terms in negotiations will almost invariably not amount to a representation about what is being offered as the contract term. And there's a very helpful and pithy statement by Lord Justice Lloyd in Leophilis and Lonsdale Sports, 2008. Mr. Maclean argued that representations are made in the draft of a contract. Pause there, ladies and gentlemen. Consider a set of negotiations. A draft is put forward to you. And in the draft, there are various statements as terms of this draft contract. Are they representations? What are they? So Mr. Maclean argued that representations are made in the draft of the contract, and that the representee enters into the contract in reliance on and after those statements made in draft form. Now you can see that that argument has, in a way, legs. And what was important about the Idemitsu decision was that it said that a previous decision, which held that that was the case, was wrong. It seems to me that the answer to that is the draft is no more than a statement that if and when the contract is entered into by all relevant parties, the particular party will make the statements in question, just as it will undertake obligations set out in the draft. So effectively, in a draft contract, it can be very difficult to find representations. Mr. Justice Andrew Baker QC, as he then was slightly more nuanced in Idemitsu, recognizing that it could give rise to a representation, but it probably wouldn't. He said that he gave an example about a warranty in a sale contract. The product will be of such and such a quality. When a seller, by the terms of a contract under which he sells, warrants something about the subject matter sold, he's making a contractual promise, nothing less. But I also think, all things being equal, nothing more. That is just so much. That is so just as much for a warranty as to some then present or past matter of fact. Pause there. Certainly, in the market circular, there was a representation as to the last 3 voyages, as it is for a warranty as to the future. Pause there. Is a speed and consumption statement something which is only for the past, or does it also extend into the future? And I'll come back to that. It's rather interesting what happened in the first instance decision on that. By contracting on terms by which he warrants something, the seller is not purporting to impart information. He is not making a statement to his buyer. So that, as you can see, as you come up to the first fence in arguing Capital's case, was a problem, because in one sense, the statements had been made in negotiations as to what was going to go into the charter party. That's the first strand. And that first strand has been tweaked and developed in the particular context of speed and consumption warranties in the second strand. Next slide, please. And this is a case called the Larissa in 1983, a decision of Mr. Justice Hobhouse, as he then was. But note how different the facts are. You've seen that in our case, the Sea Challenger, what was sent out was a market circular, not a set of draft terms, but here, this is what SK Shipping is entering the time charter market, and these are the figures which SK Shipping says represent the figures for its 4-ship fleet on the basis of the last 3 voyages. So there's no term being offered in that representation. But consider the very different facts in the Larissa. There, the offer was made purely as by the broker sending, not a market circular, not a set of information, but simply sending out a draft charter party or draft charter party terms in an invitation to treat. And the charter party terms were simply set out as they would be in the charter party, that said performance, owners to guarantee 14.6 knots, etc., etc., etc. The charter was then concluded on those terms. The charterer contended that by offering those terms with 14.6 knots in them, there was a representation by the owner as to the vessel's actual speed and consumption, on which it had relied in entering into the charter party. And before the LMA arbitrator, the charter won. The arbitrator held that that was a representation which was being made. Here, look, I'm prepared to contract on these terms. Therefore, that contained, wrapped up within it, the representation that the vessel actually did 14.6. Mr. Justice Hobhouse set that award aside, and in his judgment, he held that the words of the telex were those of an obligation, i.e. a future obligation which the person was willing to enter into, rather than a representation. And he said this: these words, on their ordinary meaning, are words of contractual offer relating to a contractual term. The contractual term is a term of obligation, not a term of representation. As a matter of law, I hold that the correct interpretation of these words in the text is that they are words of obligation, not words of representation. Now, ladies and gentlemen, I think you will already be on to the point that therefore the Larissa, although as we'll see, the Larissa played a big part in the reasoning of both courts, the Larissa is a very different case from our case, because in our case, there was no offer of a term at the beginning. The market circular is a market circular saying, look, this is what my ships do. Well, that's the question. So those are the two strands of law. Now let's turn to the first instance decision of Mr. Justice Foxton. Next slide, please. Here is Mr. Justice Foxton, a judicial, I think I can say fairly, a judicial heavyweight in the commercial court. And he had to deal with 6 very, very complicated issues in a very long and very careful judgment. We're only going to deal with the misrepresentation issue. And I want to summarize what the findings were and the holdings were that he made in quite a long judgment. So I have to, as it were, do this in a summary form. But I think it can be summarized conveniently and accurately as follows. Next slide, please. First, the judge held that the market circular was a representation. So Capital, as it were, got themselves past, or they thought they had, the Larissa problem. And Chris Smith QC, also from Quadrant Chambers, with whom I had the pleasure of arguing the case in the Court of Appeal, argued, based on the Larissa, based on EWCA, based on Leophilis, that really what had happened was that this was just the offer of a term. The judge rejected that. And it's important to know why, because this is an object lesson for owners for the future. I do not accept Mr. Smith QC's submission that the speed and consumption data in the 22nd November 2016 letter, that's the market circular, which we've heard so much about, should have been understood solely as a statement of the warranties which SK Shipping was willing to offer, and not as a representation relating to the actual performance of the VLCCs. Can I ask you, ladies and gentlemen, to note the words actual performance, because I want to come back to that. In particular, the statement that the data was based on average of last 3 voyages was representational in nature, including that the data reflected or was consistent with the recent historical performance of the VLCCs. And then the judge distinguished the Larissa. Not only was this language not promissory in nature, in contrast to the language of the Larissa, but it was language of a kind which would not have been appropriate in a purely promissory statement. If speed and consumption performances of this kind were being warranted, it wouldn't matter for the purposes of any promise whether the data was the average of the last 3 voyages of the VLCCs or not. So a very careful analysis of absolutely every word in that market circular. Some bits might be the offer of a term, other bits were plainly going beyond that and being representational. And remember that those words, average of the last 3 voyages, did not make it into the charter party. I'll come back to that. So Capital get past base 1. They've got a representation. So far, so good. Next slide, please. But unfortunately, in terms of what that representation was, Capital didn't do quite so well. Capital had contended that SK Shipping, and I set out precisely what the submission was, expected the vessel to achieve substantially the same performance in the future in the event that they were chartered. Pause. I ask you to consider why they are giving this information to a charterer when a charterer has to make calculations as the economic bargain, not for the past, because he wasn't the charterer of the vessel then, but for the future, and had a reasonable grounds for that expectation, or that SK Shipping had no reason to believe that the vessel would not achieve substantially the same performance in the future in the event that they were chartered. So effectively, the case was, well, by giving us this information, and by saying it's based on the average of the last 3 voyages, so the voyages right up to and before the marketing of the vessel, the case was that necessarily carried with it a representation, and that's going to continue. it's just in the past and we're not saying anything about the future. Mr. Justice Foxton did not agree, and he held that it was too inherently uncertain, given the uncertainties of the future and how long, 2-year time charter party in which things could change. And therefore, he read it that any reasonable reader, any reasonable charterer reader, would read it simply as an explanation of how SK had arrived at the figures which it was prepared to warrant. So in other words, a two-stage analysis. One, these are the past figures. On the basis of those past figures, I'm prepared to give you a speed and consumption warranty, a promise, but I'm not saying anything about whether the vessel will actually do it. And you may think, ladies and gentlemen, that that's a slightly odd result where a representation has been made about the last 3 voyages. And unfortunately, Larissa came back into the play here because the judge was plainly influenced by the Larissa, because although he just distinguished the Larissa, he also applied the Larissa as good law, because the mere offer of a speed and consumption warranty and a continuing warranty guarantee, as in the Larissa, should not of itself be held to involve an implicit representation as to the vessel's current or recent performance. But there's a tension here, I think. Next slide, please. Because I think that really walks a rather fine line as to how you're construing the representation which the judge plainly found had been made. I couldn't find a picture of a High Court judge on a tightrope, and they exist. Here's a lawyer. He must be a lawyer because he's wearing a tie. Here's a lawyer on a tightrope. And let me explain what I mean about that tension, and ask you again to come back to why the owner is giving this information. What is he seeking to achieve by it? Next slide, please. As Lord Justice Mayles stated in the Court of Appeal, and I come back to it as I said I would, it is in a ship owner's interest to present its vessel to the market in the most favourable light in order to secure employment against competition from other owners. So ask yourself these rhetorical questions. What was the point of the information being circulated by SK Shipping to the market? Was it, as we were arguing strenuously, to describe what SK's vessels could actually do and were thought capable of doing for the purposes of the charter party, or just what they'd done in the past? And just analyse that before you get it into a term of the charter party. What's the purpose of that representation? So we argued that it was obvious to say, this is what my ships have just been doing, and that's what they can do. That's what we said was the necessary unpacking of the representation that any reasonable charterer would understand. And there is a tension, because Mr. Justice Foxton made another finding as to the market circular representation, which is this. I accept that in putting forward the speed and consumption data in the terms in which they did, SK Shipping was impliedly representing that it was not aware at the date of the representation of any reason why the data had ceased to be broadly representative of the VLCC's recent performance at that date. The clear purpose and effect of providing the speed and consumption data in the context in which it was offered was to provide some assurance that any warranties offered were compatible with the VLCC's recent performance. Now, I really do find that a very complex way of analysing it. You're saying, well, I'm offering the speed and consumption warranties because they're compatible with the recent performance. But surely then you're also saying, we argued, that you're actually saying the speed and consumption figures actually correspond with what we think the vessels can do, will do. So that was holding number 2. So capital had got its representation, but it was very narrow. And then holding number 3, next slide, please. The judge effectively held that the representation, as it were, wore out. Because yes, there was a representation made with the market circular. Yes, it was repeated in the negotiations, but when the draft charter party was drawn up, there was no representation in the draft charter party. And that, again, is an aspect of the case that repays some careful thinking about, because you have the representation clearly and plainly and unambiguously made in the circular. You then have negotiations which simply take that text and cut and paste it in the negotiations all the way through. There were a few changes here and there, but it more or less stayed all the way through. And the judge found that the language in the offer made as a proposed term of the agreement did not constitute a repetition of the representations made, but merely a statement of the contractual commitments being sought, offered, and ultimately agreed. And so we've had strand 1 being applied with Larissa, and Mr. Justice Foxton then applied strand 2, Idemitsu and Sumitomo, the decision of Andrew Baker QC, which I've spoken to you about. And he said, these statements communicated, so far as material, no more than a willingness to give a certain set of contractual warranties in a concluded contract, and could not give the terms of those warranties a different character at that stage than it was to have, and the event did have, when the charter party was duly concluded. So in effect, the negotiations and the borrowing of that text into the negotiations washed clean or washed out the effect of the representation for all purposes. And just stepping back, you can therefore see how difficult it is, not just in a speed and consumption case, but in any case where representations are made, and then the representations influence what is happening in the negotiations, whether they can ever really survive as representations. So off it went to the Court of Appeal, because Capital lost. Next slide, please. And I had the privilege of arguing the appeal before a very strong bench of 3 ex-commercial court judges. Which is, usually you get 2. If you're lucky, you get 1. If you're very lucky, you get 2. But I got the jackpot, I got 3. So I had in the centre Lord Justice Nails, who was presiding, and then Lord Justice Phillips and the new Lady Justice Carr. And I think that the hearing was meant to be live streamed, which would have offered you all a very good opportunity to watch me being knocked around at the court. It's always very good to have a proactive court. I enjoy proactive argument with a high-powered court. This was really rather like commando training using live ammunition, I felt, after the 2 days were over. But perhaps I can just take you to the next slide, which summarizes the decision. Next slide, please. Thank you very much. The appeal was dismissed effectively on the same grounds that Mr. Justice Foxton decided, although there were some, there's a really important and interesting aspect, I'll come on to this right at the end, in relation to what you do if you do have a representation and how you can exercise the right of rescission, and how the court exercises the discretion to validate the exercise of the rescission under the Misrepresentation Act of 1967. Unfortunately, time does not permit me to go into that issue. It would make a lecture all of its own, but bear that in mind. And there's some very important criticisms, veiled criticism, but criticisms all the same, by the Court of Appeal of what Mr. Justice Foxton had said the law was. And that's going to be important in future rescission cases. But again, that's general, not just speed and consumption related. So I returned to the fray and said that I submitted that a representation as to the expected performance in the future was necessarily implicit in a representation as to the actual performance in the most recent past. So I said that when they made the representation, this is what our vessels have just done. They were obviously making a representation, and this is what they will do, or this is what we expect them to do, or at least we have no reasonable basis for believing that they won't do this as they did in the past. We argued what else was the point. The Court of Appeal did not agree, and they set the test right, but I ask any charterers or any owners who may be watching this presentation to ask themselves the same question that the Court of Appeal posed itself in paragraph 36. The issue is how the market circular would be understood by a prospective charterer familiar with the market. Well, he might understand if somebody's just offering a set of terms. Here's my draft charter party. He'll understand that it's just being offered a set of terms. But if a market circular is coming out saying, hi, we're SK Shipping, these are our vessels, we're joining the time charter market, would a prospective charterer really have read that in precisely the same way as the charterer would have done in the Larissa? Well, it's a matter which is certainly open to doubt. I might put it rather more strongly than that, but I won't. And what the Court of Appeal said was, in its judgment, the prospective charterer would have understood the owner to be saying, this is how my vessel has performed on its most recent voyages. And these are the warranties which I am prepared to give, and nothing more. This would be enough for the prospective charterer to decide whether to pursue the negotiations. It might be a reasonable inference that the owner believed that it would be able to comply with the proposed warranty after taking account of the 0.5 knot margin. That's almost difficult to contest, I would suggest. But it does not necessarily follow that the owner was making any representation about this, let alone going further. And again, I think that really is a very tortuous analysis is the wrong way of putting it, but it is a rather difficult analysis, I think, but plainly highly influenced by the Larissa. The speed and consumption warranties, when they're being given, they sort themselves out in the charter party and don't usually amount to representations. So, the next slide, please. There is an application pending, you'll be pleased or not pleased to hear, to the Supreme Court to take this matter further. Here is a picture of the Supreme Court in summer sunshine in London. Next slide, please. Where are we now? What I want to do is just very briefly to highlight a few takeaways. They may be pretty obvious, but I think they're still worth stating, both for owners, because this case throws up some problems for owners, and for charterers. It certainly throws up problems for charterers. So if I can have the next slide, please. For owners, just think about how this case started and ended up with long and vexed litigation. Simple answer, avoid market circulars. If you're going to be putting your vessels onto the market, qualify any information expressly as being these are speed and consumption figures which we are prepared to contractually undertake, full stop. That then puts you fair and square in the Larissa. Indeed, it puts you even stronger within the Larissa, and there can be no case about representation. But I ask as a shipping lawyer, because I do lots of other law as well, the third question, why do we never see, or very, very rarely see, in charter parties an entire agreement clause that says this is the entire agreement of the parties which supersedes all previous representations, warranties, discussions, and so it's absolutely standard boilerplate, as you will all know, in any other type of commercial agreement, but we never see it in a charter party. And you know, it seems to me that would be a very useful thing to put in a charter party, just to make sure that the representation issues, apart from fraud, of course, fraud unravels all, but the representation issues are boxed off. And even on the modern forms of standard form charter party, there's no entire agreement clause. And that strikes me as odd. Perhaps it's because many charter parties are concluded in fixture recaps and telex, email negotiations, and then the charter party only ever finally emerges. But take the commodity trades. Very fast-moving trades are done in WhatsApp exchanges or emails, and very often there is an entire agreement clause and a no waiver clause, the usual boilerplate at the end. So that's certainly a suggestion. Next slide, please. For charterers, I think it's more difficult. If the speed and consumption figures really are essential to the decision to enter into this charter party you're contemplating, so that you won't be satisfied with the remedies. And the remedies are often not very satisfactory because, yes, you can adjust rates of hire with a clause like clause 24. Getting a repudiatory breach if the vessel significantly underperforms or overconsumes, is very, very difficult. In the Sea Challenger, a case of repudiation was run in the alternative. It failed because it's very, very difficult to find a repudiatory breach. So if you want a rescission type remedy, then you need to be more proactive about it in the negotiations and obtain a representation. And ask them to represent what they're doing. If the owner won't, then that might tell you something about how good the speed and consumption figures really are. But there is a well-known remedy. I've set there the case Eurovideo Bildprogramm GmbH and Pulse Entertainment Limited, where, and you find this in share and sale purchase agreements, where not only do you warrant it, you represent it. And that offers a very neat way of bringing what is also a warranty in as a representation. So that's, next slide, please. I'm just about to bid farewell to the Sea Challenger case and bring my presentation to a close. But before, and there is a Sea Challenger on her way out, but before I do so, I want to ask a question which Trishli said I was going to cover, because we all know that in shipping, we are constantly, and in other contexts as well, we are constantly reserving our rights, all rights reserved. How often do you see that? Without prejudice to all our rights, all rights are reserved. And the Sea Challenger raised a very interesting question about that. Next slide, please. Which raises the question, when is a reservation of rights ineffective to reserve your rights? So you might actually be reserving your rights in categoric terms. But can that be undone in certain cases, where it doesn't matter how, whether you've typed it in red, underlined, and in bold, it doesn't matter that you're reserving your rights, because you can't. And that was the aspect that came up as issue 3 in the Sea Challenger, and I leave you with it because I think it's something we all need to think about, advising clients on a day-to-day basis when we're reserving rights in a developing situation. Next slide, please, and you'll be glad to hear, ladies and gentlemen, the last slide. I pose the question, the answer is, when the reservation of rights accompanies the demand of substantial contractual performance of a kind which will lead the counterparty or third parties to alter their position in significant respects. Now, how it came up in our case was capital. I've told you that they terminated in month 8. When the problems first came up, SK Shipping said, you need to give us 6 months. We're fitting a new super device on the engines of one of the ships, which will monitor and address the problem. You need to give us time. And every time Capital Shipping complained, SK Shipping said, give us time, it's probably hull fouling. And shortly before cancellation, Capital actually put an experienced engineer on board to try to work out what the problem was. Throughout that history, they were reserving their rights. Earlier, specifically about the overconsumption issue, but then just saying all rights reserved. Held by Mr. Justice Foxman and the Court of Appeal that a reservation of rights could and usually would be wholly ineffective if one was asking the other party to perform while investigating the matter in relation to which the rights were being reserved, because the conduct might be so inherently affirmatory, as they put it, that the reservation was ineffective. In other words, you can't say, I'm reserving my rights, but I'm going to send you on a long-laden voyage. Because the order to go on a long-laden voyage is so affirmatory of the charter party. It involves third parties being involved, sub-charterers, etc. You can't still be reserving your rights. And the question came up in the Court of Appeal, well, if you had reserved your rights, could you then have terminated the charter party during the next voyage or only at the end of that voyage? And that was said to throw out the complications. But there is real interest in this reservation of rights point, and that is another point that, if Supreme Court gives permission, will be argued before the Supreme Court, because there are 2 strands of authority. There's this, which is new, the concept of inherently affirmatory. That has not been used before, as far as we were all able to test, counsel on both sides. But there is also a body of learning. Sean Wilkins' book on misrepresentation is important, which says that a reservation of right is necessarily effective. You can't unreserve something which you are reserving. because the reservation of rights makes ambiguous what you're doing, and it says you can't rely upon my next conduct after this reservation of rights as being affirmatory. Anyway, I've gone on long enough. Thank you very much indeed for listening to me. Next and last slide, please. And thank you very much indeed for your attention. It's been a great pleasure addressing you. And I'm very glad to see in the Q&A box that there are only 2 questions. That's very good news for me.
Thank you very much, Simon, for that presentation and for taking the time to unpack some very complex reasoning. So we'll now move on to the Q&A session. The first question we have is from Sherry Teo. Just a quick question. Is there any hybrid charter party for dredging? Alternatively, is it possible to have a time charter and work-based charter party in the context of dredging?
I'm not sure that's a question which really comes out of the lecture. I've never come across a hybrid dredging charter party. I don't quite know what the concept would involve that the questioner is contemplating. I mean, I suppose one way of dealing with it would be rather like a supply time or a token form where there is a time element, but also it's for a specific service where the nature of the service is set out in the box. That might be the closest you can get to a hybrid charter party for dredging. I don't think, I've never come across a standard form for dredging. Perhaps BIMCO need to turn their attentions to have DredgeCon or something like that. But so what's the next question?
The next question is, would it be convincing to add a qualification in whatever promotional materials there are to the effect that this is the vessel's present capability, but its future performance would depend on various factors which cannot be exhaustively predicted at this time? So that's essentially the statement.
Yeah, I'm reading it on the screen as you're reading. Thank you.
It alludes to capability, but also makes it clear at the same time that it is not a representation. Do you reckon it will fly?
Well, I think that's a really very interesting question. I think the danger word there for owners is present capability. I mean, that actually takes it slightly further than based on last 3 voyages, because at least based on last 3 voyages, that was a statement looking to the past. But if you say this is, and note the present tense of the verb to be, if this is the vessel's present capability, you've got a real re-emphasis, haven't you, on capable, present, is. And I think that while of course they can say future performance may vary on because of weather, cargo, hull fouling, whatever it is, but nevertheless, if on the day that charter party is signed, those vessels can't do it, it doesn't matter what the future performance and exhaustive predictions are. On day 1 of the charter party, on delivery into charter service, just like on the SK ships, they couldn't do it because they had no such present capability. I don't think that caveat would, that qualification would really work. And I think, indeed, it might have been a rather stronger case for us had the market circular said this is the vessel's present capability, but unfortunately not. So I think it's a very interesting question. I think that actually goes the other way. Again, if owners want to avoid this problem, I think you have to have some wording like, this is what the vessel has done up to now, and based on that, we are prepared to warrant the figures in the charter party. And then that effectively sets out expressly what the Court of Appeal and Mr. Justice Foxon said. Good question, thank you.
Thank you, Simon. We have another question. We discussed giving order and reserving of rights. What if the charterers misrepresent and owners accept order under protest? For example, if a vessel is laden when it is discovered that there is a misrepresentation, can there be a termination after discharge to reduce risk and the trouble while the vessel is laden?
as I understand it, the misrepresentation is made, which is actually made as to the order with which the owner is being asked to comply from this question. And if that's right, then if the owners say, well, I carry out that order under protest and reservation of rights, I think it would be difficult for the owner suddenly in the middle to terminate. It depends. I mean, if he says, I'm very unclear about this order, and I will investigate it and I'm reserving my rights, but then goes on to perform or part perform the order, then I think you are into the difficulty of the inherently affirmatory position. I mean, let's take a very common example. Order to a particular port, which the owner contends is unsafe and carries out the order, and the charter says, no, I represent it's entirely safe, and the owner carries out the order under protest. I think termination is not really the position. All you've done is you've reserved your position to claim damages for the fact the order was actually unlawful because the port was in fact unsafe. So I think that's my answer to that.
I'm just checking if there are any other questions.
Big Ben is striking 10 o'clock in London. I can just hear it. The wind is in that direction.
And with that, I guess we have now come to the end of this webinar. On behalf of IMSML, I would like to thank you again, Simon, for taking the time to share your thoughts and views with us. And I also wish to thank all the participants for joining us today. We hope to see you at our future webinars. The slides will be made available after the webinar. And yes, sorry, Simon, you wanted to say something.
No, may I just again thank the Society for inviting me to give this lecture. It's a great privilege, and I'm very, very pleased to see that there are so many participants with a very, very slow fall-off rate, which is always very flattering. Thank you all very much indeed.
It really is our pleasure. Thank you very much. Everyone, have a great day or evening ahead. Thank you.